Hello friends, Mandar here. I am back with another video. In today's video, we are going to talk about some more clarifications on the USCIS policy alert about which I made a video last time. I wanted to clarify what is transfer of underlying basis, what does that mean, and who is qualified to apply for the upgrade from EB2 to EB3, because there has been a lot of confusion, a lot of emails and a lot of messages to me, and I'm pretty sure a lot of people are confused with this message. So let's clarify who are the people who should do this upgrade and what does this transfer of underlying policy mean, and what does this transfer of underlying basis mean. So don't miss the content of this video if you are in this situation, and let's get started. If you are here for the first time, welcome. My name is Mandar and I make immigration related videos for US and Canada. I'm not an immigration lawyer, so anything that I say on this video or on my channel is for information purpose only. And for your specific immigration needs, before you take any action, you should hire a competent immigration lawyer. Now, before we get started, I would like to mention that if you would like to discuss your particular scenario with me and to get my personal opinion, you can contact me on my Patreon site. I'll leave the link in the description and also displayed on the screen. Remember, my response will be my opinion only. It should not be constituted as a legal advice because I'm not an immigration lawyer. So before you take any step, you should particularly consult a good immigration lawyer. So USCIS put out this policy notice, policy alert for mentioning that there are a lot of visa numbers available for EB1 and EB2 category. Now we are not going to go into the details where these visa numbers came from. I made my speculation in my last video. So you might want to check out my previous video regarding the details of this policy alert. I go into the depths of explaining what it means and how it impacts your possibly your case. In this video, I'm going to clarify some questions or some confusions in regards to this policy alert. Now, first of all, I wanted to say is everybody in EB3 or most of the people in EB3 got excited about this particular policy alert. They thought that if you are in EB3, USCIS is telling them to upgrade to EB2 regardless of any conditions, and that is not true. That is the first clarification point that I want to make, that they have specified under very certain circumstances you should upgrade your case from EB3 to EB2 in a certain way. Okay, so what way that is, we'll come to it in a moment. But who is eligible? Let's read the exact line and paraphrase on this particular condition. So what does USCIS say? I have highlighted this section. If you have a pending adjustment of status application based in the third employment based preference category, but also have a pending or approved petition and an available visa in the second employment based category. So remember, they are talking specifically about two conditions. You should have a pending or approved petition and a visa number available, which means your EB2 priority date should be current. Only if you have these two conditions met, only then you should consider upgrading from EB3 to EB2. So remember, not everybody is eligible. It's only those people who have an EB2 petition either in process or approved and whose priority date is current in EB2. Only those people should consider upgrading your petition. Now let's look at the second part that I wanted to clarify. In the policy alert, USCIS mentions that we strongly encourage you to request that USCIS transfer the underlying basis of your pending application to the second employment based preference category. So they call it as transfer the underlying basis. What it means is, if you already have an application pending with USCIS in 485 or I-140 for EB3, then you can transfer that underlying basis, which means you can ask USCIS that now that the petition that I have with you in EB3 category, please change it to EB2 category. And here are the reasons why. Here is the supporting documentation for that upgrade from EB3 to EB2. Now, transfer of underlying basis, it is just a fancy name for interfiling. Now I will tell you, this interfiling is nothing new. Interfiling is done in various different cases. So if you have a pending petition and if you want to change something about that petition, the way you do it is, instead of filing a brand new petition, you make a modification to the existing petition, whether it is an address change, whether it's a category change, or some information that is updated. Even when you submit your medicals in your final adjustment of status situation, that is also something called interfiling, because there is an existing petition and you are just adding information to it. So this is what it exactly means, the transfer of underlying basis. So they are asking that if you fall into this category where you have a approved or pending EB2 application, and if your EB2 priority date is current, then you can change or transfer the underlying basis of your existing EB3 petition to EB2 petition. But here's I want to add something more to it. Now there are two methods by which you can do an upgrade. If you fall in the category where your EB2 date is current or about to become current, you might want to actually upgrade your petition from EB3 to EB2. Now a lot of people had downgraded the petition from EB2 to EB3 in 2020 because all of a sudden EB3 started moving very fast and EB2 was very slow. A lot of people, means thousands and thousands of people have downgraded their petition from EB2 to EB3 in the last 1.5 years. Now what has happened is, now EB3 has stalled and EB2 is moving faster. Now all these people are upgrading or contemplating upgrading, and now USCIS has poured fuel into the fire, and by putting out this policy alert that there are a lot of visa numbers available in EB2, now all of a sudden a lot of people are thinking that okay, I'm EB3 now, I should go into EB2. But be careful, if your date is current or just about to become current, only then consider elevating your application from EB2 to EB3 to EB2. The reason is, you never know. This is the way things are moving, and it has happened in certain other categories. These things can flip-flop. Sometimes EB2 will become faster, sometimes EB3 will be faster, and then you will always be in this queue jumping mode where you have upgrades and downgrades and upgrades and downgrades again. You'll be losing a lot of money in this translation. So only under certain circumstances should you try to upgrade your application from EB3 to EB2. Now if you want to discuss something with me, contact me on the Patreon site and I'll be happy to give my thoughts, not a legal advice but my thoughts on your particular situation regarding what I would do if I were in your shoes. Now let's get back to interfiling. If you think that you qualify for this particular scenario to take advantage of these visa numbers in EB2, there are two ways you can upgrade your petition. One is you can do this interfiling, which is exactly what they are saying, transfer the underlying basis. That is nothing but interfiling. So that is one. Now and then the second method is to file a brand new EB2 petition, basically brand new I-485, I-140 in the EB2 category. Now what that will do is that will give you a receipt number. So when you are filing a new petition, you will get a receipt number because that is a separate case. In parallel, it has nothing to do with the existing EB3 petition. So it will be a parallel petition in EB2 with its own receipt number, own tracking and everything else. But with interfiling, you will not get any receipt number because you are just asking the USCIS with a letter and some sort of supporting documentation as a proof to elevate your case from EB3 to EB2. That's all you are doing. USCIS may not give you any response back. USCIS will not give you any receipt number in this particular interfiling situation. All you will know is your case may have been elevated to EB2 and it will probably get processed, but it will be very hard to track whether that has actually happened. So that is the main differentiation that I really wanted to point out, whether to interfile to upgrade or to file a separate EB2 application for your 485 and I-140. So this is a distinguishing feature, because by filing a separate petition, you will get the tracking number, you will get the notice, receipt and everything, and it will be a clean parallel application in EB2 category. Whereas In interfiling, you are upgrading your existing EB3. There is not going to be any proof and there is not going to be any traceability available from USCIS to you in regards to whether your application was indeed upgraded and whether it's following the course. So there is not an established process for interfiling. Remember that it is a hit and miss. Some people are lucky with this process, but some are not lucky so much. Assess your situation and then take a decision whether you want to interfile or whether you want to file a fresh petition in EB2 I-140. So that's up to you. So that's really what I wanted to cover. The second one is there is other difference is for interfiling. It's simple letter to the USCIS. It's going to be a cheaper option. Whereas when you if you try to file a separate petition in I-140 for EB2, that is going to have all the fees again that you have already paid in EB3 track. So basically filing fees, lawyer fees and everything else will go along with the fresh petition. So that is something to keep in mind. Now really, as I said, USCIS has put fuel to the fire by saying that there are a lot of visa numbers available in EB2 and you should be upgrading. But carefully assess your situation. Do it only if you are current in EB2, I would say. Don't do it if you are not current in EB2. Just because the EB2 is moving faster, but you are still not current in EB2, you anticipate that you might get your green card faster. That is a wrong assumption in my opinion, because we saw EB3 was moving much faster, years ahead of EB2 just a year and a half back. And now EB2 is moving year and a half ahead of EB3. Who knows, it will flip back over to EB3 again. EB3 might start moving faster again. In that case, what are you going to do? You already downgraded, now you are going to upgrade and downgrade again. So carefully assess your scenario, what makes sense. Follow your lawyer's suggestion if they are willing to give you, and go by that. Now another situation a lot of people are into is they have this upgrade situation where they think that they should be upgrading from EB3 to EB2, but in the meantime they are also contemplating job change. Now this is a tricky situation, because should you upgrade your petition with your current employer, or should you first do the job change with AC21 rule and then ask your new employer to upgrade it? Now this is very tricky situation, and a lot of things come into play. Make sure that your I-140 is approved before leaving your current company, because if your I-140 is not approved, then you don't have any priority date, or you don't have anything to go along. You have to start all the entire process again with your new employer. But whereas if you have I-140 approved and if you have been on I-485 for 180 days plus, then you can avail the AC21 job portability situation to change your job into the new employer. And when you join your new employer, then you don't have to go through PERM and labor certification, even 140. You can just apply your supplement J 485 and continue with your process. Then in future, if you want to still upgrade from EB3 to EB2, you can still do that, but at least you don't have to start all over again. So that is important. Another point is difference between interfiling and creating a fresh petition for EB2. You might be in the process in the interfile, you are already in the process, you are already in the queue at a certain stage in your adjustment of status. So you are just changing your petition, but you are still in that particular phase. Say for instance, you have got your EAD, you have got your biometrics done, and so on and so forth. For the fresh filing of I-485 with EB2, you might go back in the queue of your EB2. So consider like this: there is a pool of applicants and it's first come first serve. So if you are already been in EB3 queue for a long time, you are probably ahead in the queue, within the queue of the pool of applicants who are current. But now if you change, or if you file a fresh petition in EB2, you might go into back of the line between the pool of applicants who are already current. So that is something you want to consider. So it's not always to say that if you jump from EB3 to EB2 that your application will be faster. That might not be the case. It will depend on where you are in your EB3 queue versus EB2 queue. So that's all I wanted to say. You have to consider a lot of pros and cons, a lot of carefully assess your situation, where you are with your EB3 petition, how close you are to getting your final action date current, and all sorts of things in order to determine whether you should take advantage of this policy alert that of upgrading your petition to EB2. So that's all I wanted to say in this video. If you like the content of this video, please hit the like button and consider subscribing to my channel, and I'll see you in the next one.